Calling case C181554, Ramos versus Nielsen. Counsel, please come to the podium and state your name for the record.
Morning, Your Honor. Ahilan Arlanandam for the plaintiffs.
All right. Good morning.
Morning, Your Honor. Jessica Karp-Bansel for the plaintiffs.
Thank you.
Your Honor, Rhett Martin for the defendants.
All right. Thank you, Mr. Martin. I don't know if you all want to make an appearance.
Your Honor, Alicia Dagan for plaintiffs.
Good morning, Your Honor. Emmy Lou McLean for the plaintiffs.
All right. Thank you. All right. We are on, first and foremost, this morning for hearing on defendant's motion to dismiss. And I think the first issue we have to address, of course, is the jurisdictional stripping provision in 2554A. But before we get into that, I just want to make sure I understand exactly what the theory of the plaintiffs are. The plaintiffs are challenging not the designation or undesignation of the four countries per se as designated under the for temporary protective status, but the change in the rule or interpretation of that statute. Is that right?
That's correct, Your Honor. As to the APA claim, that's correct, Your Honor.
And is the change, what is the scope of the alleged change? Is it not considering any current and intervening circumstances or disasters, or those not considering those which have some exacerbating or prolongation of the originating condition? And does that make any difference in this case? I don't know.
Well, I think if you look, for example, at the Nicaragua designation, in 2012,
Calling case C181554, Ramos versus Nielsen. Counsel, please come to the podium and state your name for the record.
morning, Your Honor. Ahilan Arlanandam for the plaintiffs.
All right. Good morning.
Morning, Your Honor. Jessica Karp-Bansel for the plaintiffs.
Thank you.
Your Honor, Rhett Martin for the defendants.
All right. Thank you, Mr. Martin. I don't know if you all want to make an appearance.
Your Honor, Alicia Dagan for plaintiffs.
Good morning, Your Honor. Emmy Lou McLean for the plaintiffs.
All right. Thank you. All right. We are on, first and foremost, this morning for hearing on defendant's motion to dismiss. And I think the first issue we have to address, of course, is the jurisdictional stripping provision in 2554A. But before we get into that, I just want to make sure I understand exactly what the theory of the plaintiffs are. The plaintiffs are challenging not the designation or undesignation of the four countries per se as designated under the for temporary protective status, but the change in the rule or interpretation of that statute. Is that right?
That's correct, Your Honor. As to the APA claim, that's correct, Your Honor.
And is the change, what is the scope of the alleged change? Is it not considering any current and intervening circumstances or disasters, or those not considering those which have some exacerbating or prolongation of the originating condition? And does that make any difference in this case? I don't know.
Well, I think if you look, for example, at the Nicaragua designation, in 2012, they specifically say the roads were, I may be mixing them up. Hold on one moment, Your Honor. At the El Salvador designation, Your Honor, in 2012 when they're extending, and they say the roads have, from the earthquake damage, have been repaired, but there's other problems with the roads. If you look at Haiti, Haiti is designated because of an earthquake in 2010, but then when it's extended, they look to Hurricane Matthew. Hurricane Matthew is not caused by the earthquake in 2010. So I think it's clear that there is no way to...
And it was not extended because under the rubric of Hurricane Matthew having exacerbated the conditions of the earthquake?
I mean,
Itself was a condition that was sufficient to extend TPS?
the exception that you're describing could, I suppose, swallow the rule. It's difficult at this point to know whether, how now the government is trying to draw the line to justify the change that's happened. But if you look at the statements that were made by the government officials, and they said, for example, Secretary Kelly, the program TPS is for a specific event. In Haiti, it was the earthquake. Haiti had horrible conditions before the earthquake. Those conditions aren't much better after, but the earthquake was why TPS was granted. That's how I have to look at it. So does that permit consideration of Hurricane Matthew because it has an exacerbating effect on the earthquake? I don't know, but they didn't mention Hurricane Matthew when they terminated TPS for Haiti, and they had mentioned it previously. So, whether the government now wants to try and shoehorn what is, we allege, a change by sort of creating a new conceptual framework and saying you can put the intervening conditions that they used to consider into this box, I think that's going to be a factual, that is a factual dispute then, and we're entitled to show that their post hoc explanatory theory can't actually capture all of what the actual phenomena here. So what we're alleging is it used to permit consideration of intervening conditions. Now they
irrespective of whether it was specifically tied to exacerbating an original condition, some of them were independent of the original condition.
Yes, Your Honor, that it used to permit them regardless of whether or not they were actually exacerbating, and that now the focus is on the originating condition, and you don't look at whether they're exacerbating. But again, as I said, if they want to try to shoehorn everything into this new account of their change practice, that's a factual dispute, and we're entitled to say that, that Secretary Kelly didn't understand it that way when he terminated Haiti or when he terminated TPS for El Salvador. Does that answer your question, Your Honor?
Yeah, it does. We may get into some factual questions. If you get into like Darfur, Sudan, for instance, that probably has the most extensive analysis of current conditions that are compared to some other ones. If you look at El Salvador, in the 2016 extension, there are a number of things that were referenced, such as water access, coffee rust epidemic, various things that were cited and that were omitted or not addressed in the 2018 termination. I guess that's your point. So maybe there's a bit of a mixed record here, and some statements are a bit more robust than others, but I just want to make sure I understand the theory of your case.
Yes, Your Honor. And to be clear, this is what we were saying in the brief we just filed yesterday, I guess it was. It's been a long 24 hours. If in fact we have not adequately pled, even for 12b6 purposes, that there is an unexplained departure from the prior practice, then we lose on 12b6, but that for the APA claim. But that has nothing to do with whether there's a subject matter jurisdiction dispute, 12b1 dispute, based on 1254A B5, the jurisdiction stripping provision. Because for purposes of that, you presume that there is a unexplained departure or a new rule, and ask, would the court have the power to remedy that under the APA if in fact there is an unexplained departure? And so that whole debate about whether or not there's a new rule, it has nothing to do with the subject matter jurisdiction dispute. It only has to do with whether or not we've stated a claim. And so we're entitled to discovery. If we have stated a claim, if we've gotten that far, then we should get to find out what were the documents that Secretary Kelly had in front of him when he made the statement in his testimony. Secretary Nielsen made an even clearer one. She said, the law really restricts my ability to extend TPS. The law says that if the effects of the originating event, so that's a causation issue, do not continue to exist, then the Secretary of Homeland Security must terminate. So what was she looking at when she said that? Was she looking at a memo that said, oh, well, if it's an exacerbating condition, if the hurricane causes the earthquake recovery effort to get worse, then you can look at it? Or was she looking at a memo that said, originating condition, intervening condition? It's very black and white. And we're entitled to find out if there is such a memo, and if there is, obviously, then that would suggest
Well,
that
to get there, you have to get past the very first question, that is, assuming, for instance, that your assertions of a new policy or new interpretation are true, that may be disputed, but assuming that that's been alleged and adequately alleged, does that escape the jurisdictional stripping provision? That's what I want to address now. I think that's the most critical question. And so
I'm happy to start, but I think it's their motion.
well,
They should
it's your
probably
motion,
start.
and I have a couple questions for you, Counsel.
Honor?
Good morning. It is fairly clear, is it not, that there is a presumption that of review. There's a strong presumption that actions of federal agencies are reviewable, but upon a showing of clear and convincing evidence of a contrary legislative intent, that can be overcome. So you have that presumption, and then you have the presumption about review, judicial review, where constitutional claims have been asserted, because that raises separation of power questions if you were to find that there is no jurisdiction. So starting with that, and then combining that with the Supreme Court's decision in the Catholic Social Service case and the McNary case, which seemed to construe the term determination to mean determinations in a sort of case-by-case basis. If it's an individual, it's an individual adjustment situation. If it's a country-by-country under TPS, you look at each determination, but not to general challenges to sort of procedures or more systemic policies or changes, which is what the plaintiffs are alleging here. So why would in view of the presumption, in view of the Supreme Court precedent, which have narrowly construed the word determination to mean sort of individual determinations and not systemic sort of issues, why would that preclude judicial review here?
Well, I think there are a couple of reasons, Your Honor. First, the 1254A says any determination, and it would be impossible to separate out the ultimate decision to terminate itself from the various balancing of the factors that the Secretaries of Homeland Security have to take into account. That it sweeps in everything that plaintiffs are trying to challenge here, whether the new rule or the ultimate termination itself. And I think the distinction between the case here and McNary and Catholic Services can be seen in terms of the relief. The relief that was awarded in McNary was not an award of special agricultural worker status. It was the right to have a redo of an application for that SAW status in light of new procedures if they prevailed on their claim that the procedures were in violation of due process. Here, plaintiffs are seeking a rescission of the terminations themselves, and that there is no way to reach that without reviewing the determination.
Well, but the ultimate, if you're looking at the ultimate relief, the rescission of, if what they're seeking is a rescission of these determinations, that would not preclude a redetermination of further, that's procedurally correct, for instance.
If this were in the McNary sort of world, that would be true, Your Honor. But our position is that we're not, because first of all, the new rule doesn't exist, which can be determined on the face of the Federal Register notices alone. And secondly, even if it did, what they're calling a new rule is part and parcel of the determination itself. There is no way to segregate out the decision to terminate.
But wasn't that true in Catholic Social Services and McNary? I mean, they were challenging the INS's interpretation of certain criteria, which determined whether adjustment of status was available or not. I mean, so it informed the determination in the case, and in fact, they said that ultimately, in a deportation context, perhaps these issues could be raised. So it is tied up in both situations. The determination of the systemic problem has an impact on the individual case. I don't know how you can separate that in either one of those.
Well, in Catholic Services, for instance, it was a rulemaking. It was a formal rule that was being challenged, or regulation that was being challenged. And in McNary, it was the formalized procedures about how you would apply for this status. There's nothing like that here. What we're challenging here is the Secretary's discretionary weighing of the statutory factors that has been entrusted to the Secretary by Congress and lies uniquely within the executive's competency over foreign policy. That there is no way to extrapolate from that a rule that says, this particular factor must be weighed this much and this factor must be weighed another, or how the Secretary has come to that decision. The determination encompasses, as it says in the statute, any determination encompasses every aspect of the decision-making process. And so,
So you would emphasize the word any? Is that why it's broader than just determination? I'm not sure what other word could be used when describing, if you intended to focus on the determination country by country, the designation. I don't know what other word you would use besides any.
Well, that is emphasizing that it's all-encompassing in terms of the factors that the secretaries are considering. And it's also worth noting that the legislative history says none of the decisions with respect to TPS should be subject to judicial review.
But it's not specific in terms of, again, that sort of echoes the language of the statute. I'm not sure it sheds much light on, for instance, challenges to constitutional or systemic type issues.
Well, our position would be that none and any are both sort of unqualified terms that sweep within them every aspect of the decision-making process.
What about the fact that in McNary, the Supreme Court, as part of its analysis, talks about if judicial review were limited, that is a challenge that's of this nature here, whether it's a constitutional challenge or to the interpretation challenge, were to be reviewed, it would be only in the context of, for instance, a deportation, if it got to the removal proceeding, and there'd be judicial review, but that would be limited to the administrative record and subject to narrow abuse of discretion review, which the court said would not be consistent normally with a constitutional challenge, which then suggests that Congress did not intend to cabin everything with the jurisdictional stripping statute and to allow room for a broader constitutional challenge.
Well, whether it's framed as an APA challenge or a constitutional challenge, Your Honor, that at the end of the day, the challenge would require the judiciary to make its own independent assessment of the factors and the sufficiency of the explanation given of those factors in the Federal Register notices. And it is that the jurisdiction prohibition addresses.
Well, I'm not sure I understand that. So you're saying if there's a constitutional challenge, that would be done within the framework of the APA, and therefore, even if that were allowed, you would still be limited to the record, that the APA scope review would be no broader than the scope of review on a removal order?
Our position, yes, that if we're talking about the discovery issues for a moment, that the review here must at least start with the administrative record.
Of course, there are exceptions under the APA. I guess we'll talk about that later in terms of when you can go beyond the record. But still, the court, notwithstanding all that, in McNary case, is, in addition to the fact that the term a determination describes a single act rather than a group of decisions or a practice or procedure employed in making decisions, noted the sort of the implications. If you didn't allow for judicial review of constitutional claims or an interpretation claim that's systemic, the normal route of judicial review would be so constricted in the context of an adjustment of status or removal proceeding that that would be inconsistent with the normal way you adjudicate constitutional or broader claims. And that seems to apply here as well. Well,
Again, to not to be repetitive, but the existence or not of this collateral practice or policy can be determined on the face of the Federal Register notices. And it is our position that the terminations here are consistent and reflect and mirror the terminations and extensions and designations given for TPS and by every prior administration. And that on that fact, the new rule theory is a predicate for subject matter jurisdiction here, and plaintiffs have not sufficiently shown that such a new rule or practice exists.
Well, all right, that gets in part to the merits questions, which we'll get to in a moment, but I'm trying to get to the interpretation question and whether McNary and Catholic Social Services is really controlling or persuasive to the instant situation. The court in McNary also notes that if Congress really intended to limit review to bar broader statutory constitutional challenges, they could have done so, and give an example of the kind of language that Congress could have used. And again, doesn't that argument apply here?
Well, Your Honor, there's different Congresses have chosen different languages over time for judicial jurisdiction stripping provisions, such as the one here. The language here is unqualified. The legislative history confirms that the language is unqualified. And again, it's hard for us to see how what plaintiffs are calling the policy or practice could be separated from each individual determination.
Well, the court gives an example that said that the Congress could have used, as happens in the veterans benefits context, barring review as to on all quote on all questions of law and fact, as opposed to determination with respect to designation, termination, extension, TPS status. So I mean that's just one of several factors, but I mean it seems like that argument or that concern would apply here as well.
Congress could have certainly chosen different language, but the language again here is unqualified and broad, and whether it's any question of law or fact or any determination, or I think the legislative history says none of the decisions. Those are all unqualified and I think broader than the provisions and examples given in McNary.
All right. Well, let me hear from the other side on that point. That one, the breadth of the language, the fact that it would seem to literally apply on its face. It says any determination, and your theory would affect that determination. It may be the challenges to an underlying broader systemic issue, but it does affect any determination. And how do you respond to counsel's comment about the two Supreme Court cases? If you look at the relief sought, is different in kind than the relief sought here.
Your Honor, so first with respect to any, the statute in DeMore v. Kim said no court may set aside any action or decision by the Attorney General, but it wasn't good enough to preclude review of a challenge to that legislation that happened to be on constitutional grounds, but I think the rationale that the court used was to cite Johnson v. Robeson and Webster v. Doe. If you look at the statute in Johnson v. Robeson, it said the decisions of the administrator on any question of law or fact under any law of the Veterans Administration. That wasn't good enough to preclude review of a constitutional claim. And then Bowen, which is 4 years before the TPS statute is enacted. So it's clearly they're legislating against that backdrop. Bowen is no findings of fact or decision of the Secretary shall be reviewed by any tribunal except as herein provided. So, that's not any, but it's no decision. So these cases are not about whether they use any or a or no, or they're about the baseline presumption of administrative review of agency action, as Your Honor had stated. And some of these statutes are quite a lot clearer than the statute that we have here, unless you say that you intend to preclude constitutional claims, and unless you specify the scope beyond just determination and say we're talking about something much broader. The courts do not read those to preclude review of claims that do not go to the particular determination or decision or whatever you want to call it. And
What's an example of language that has been construed to bar, is there an example of that, to bar even systemic or constitutional challenges?
there's not an example of one that's been read to bar constitutional challenges because the courts have been very careful to avoid the massive constitutional problem and sort of a conundrum of federal courts of whether or not they could entirely strip judicial review of constitutional claims. This statute is not close to clear enough to ask this court to wade into that extremely difficult question. Statutory claims, certainly, Section 1252b9 says no question of law or fact, and I can't remember the exact wording of it. We cite it in our brief, but it's question of law or fact. And you heard that in some of these other ones, any question of law or fact.
Yeah.
That, I think, would preclude legal claims, although they have other scope limitations, like under this subsection. So the language Your Honor just was referring to with my friend in Johnson v. Robeson, the Veterans Administration case, says any question of law or fact under any law administered by the Veterans Administration. And so then we've got that analogy here, because we've got any determination of the Attorney General with respect to the designation, termination, or extension under this subsection. And so then, there's a separate question. Well, what does under this subsection mean? And under their view, I don't think it means anything, actually. I don't understand what their theory is for how that phrase limits this provision. But to us, it limits it by specifying that the challenge has to arise from this subsection, that is subsection B, which is the subsection which gives the Secretary the authority to extend or terminate TPS decisions. And what the statute says is the Secretary has to determine, use the word determine, that the country no longer continues to meet the conditions for designation. And so that's what the statute bars review of. If you say, oh, we disagree about whether the coffee rust, leaf rust epidemic actually has abated sufficiently to permit the return of people to El Salvador, that's the determination that the statute is directing you to in subsection B, because that's what it says under this subsection. If that's your challenge, then there's a jurisdictional problem, that you're challenging whether the country no longer continues to meet the conditions for designation. We obviously do not challenge that. Our challenge is to the criteria that go into making that determination. And the rule that says that the government has to explain and justify a massive revision to the criteria, that arises from the APA. It's the APA that requires the government to explain when it engages in a substantial
But in a literal
departure.
sense, changing the criteria, as you allege, that results in a termination challenging that is, in a sense, a challenge to the termination, just the basis of the termination. If they had made a factual basis using the same criteria, let's say they took all the conditions and considered intervening hurricanes and volcanoes and droughts and said, we've looked at it, determined that they're not as severe anymore, even though that was only 6 months ago or 12 months ago, that would, I would think you would concede to be a determination that's probably not reviewable.
Yes.
If it's done on the facts,
Yes,
factual
and
assessment.
I'm a little nervous about conceding to any hypothetical without getting it precisely, but if it's a challenge to whether or not the country no longer continues to meet the conditions for designation, if that's the challenge, then it's barred by the statute. And, Your Honor, this sort of pertains also to your relief question, the second question you
What
had.
about that?
So whether or not somebody, this is CSS, whether or not somebody has engaged in a brief, innocent, or casual departure from the United States so that it interrupts their presence and bars them from legalizing. That's the issue in CSS.
Yep.
Okay. Obviously, if you say, oh, they've wrongly interpreted the phrase brief, innocent, or casual departure, the effect of that is you undo the denial of the legalization application. And it's a legal question. And CSS, the effect of the decision is to revoke, I think, thousands of denials of legalization of status. And if you look at the Ninth Circuit cases that we cite, Immigrant Assistance Project, Proyecto San Pablo, they're extending the application period. That's the relief they're granting. And they're letting people who were denied legalization just do it again. And this is standard agency law practice, right? The court sets aside the administrative agency's decision, and you vacate the decision, and that's the relief that you're granted, and that's the relief we seek here. Vacate, set aside the TPS terminations. That doesn't mean that they're barred by the stripping statutes. It always depends on the reason why you are saying the action was illegal. And if the reason why the action was illegal is because it was unconstitutional or because there was a problem with the legal interpretation of the underlying rule, then the courts permit it. And the same is true of McNary. You can see it says in the decision they reopening the cases of people who were denied legalization under the Special Agricultural Worker Program.
So the scope of relief is analogous. It's not, doesn't make the ultimate determination of removability or not, but
This means that, yes, exactly, Your Honor. You set aside the decision. If they came back and explained their departure in a reasoned way, that would be open to the agency to try to come up with a reasoned decision that would justify terminating TPS, or I think perhaps to adopt a good faith approach, I would say they should then reconsider the decision under appropriate legal criteria, and they can make a new decision. Your Honor isn't saying under the APA claim that they can't make a new decision after you set it aside. Your Honor, there was a little discussion of discovery. I could save it for later, or I could talk about it now.
Why don't we get through the various claims, because discovery may also hinge on the availability of or the viability of the other substantive claims. So why don't we...
I'll postpone this question about whether the administrative record is sufficient.
Right.
Your Honor, have further questions?
No, I want to talk about the due process, and that's why you're up here, to understand the limits and the theory of your due process claim, first on behalf of the citizen children.
Honor, if I may excuse me, I should have said this at the outset, but my co-counsel, Ms. Bansal, will be doing the equal protection and APA and TPS holder claims. I'm doing the children's claim. As far
All right.
That's permissible with the court.
All right, that's fine. What's the limit of your theory? I mean, if the idea that anything that causes, and it's not that causes separation of parent from the child, implicates, and I believe you're talking about substantive due process, not procedural due process, implicates a liberty claim that's protected by due process. The government has says, well, that would undermine, any kind of, in any context where a parent is removed because they don't have legal status here, or when a parent is incarcerated, or, any such situation. What's the limit of your theory, and what is the scope of review? If one were to find a liberty interest here, what is the standard of scrutiny?
Let me just answer that last question first. The scope of review is the review available in Moore v. City of East Cleveland, Pierce v. Society of Sisters, which is to say the government has to have a significant interest in forcing the child to choose between...
Significant interest, is that more than any conceivable interest under typical rational basis review?
Sometimes been called rational basis with teeth, as Your Honor noted at the last hearing, and you certainly can win a claim under that, as the Supreme Court cases establish, but it's not strict scrutiny. It's not a fundamental right to be denied that forced choice, which is the claim that's rejected, for example, in the Ninth Circuit cases the government relies on. To go more broadly to this question about what the limiting principle is, there is clearly an interest that every citizen child has in living with their parents and in this country. So there's no question in our view that every child has that interest. That's true regardless of their age and regardless of the reason why the deportation is happening. But it doesn't follow that the immigration law will be destroyed or that there's no way to have deportations of people who have citizen children, because this is just a rational basis test, right? So the government has an interest that comes to bear when you do the balancing. And it doesn't even have to be something that would happen on a case-by-case basis, because you can look categorically at the government's interests, like in the Adam Walsh Act in Gebhardt. These are people who have been convicted of sex offenses, and so the government has an obvious manifest interest in protecting the children in that case. Here, the protection of the children interest runs the other way, right? These are citizen children of this country who are now potentially going to be sent to places that are dangerous, that our country was very recently describing as too unsafe for the return of any of their nationals. So that's just a factor that goes into the balance. Similarly,
But if you say that the government can assert a categorical interest to satisfy the Moore test, doesn't the government have a categorical interest in enforcing the TPS scheme, that this is a temporary protective status that's meant for, as the purposes set forth in the statute, to provide temporary protection for those from, calamitous type situations and conditions back in their native country, but it's not meant to be a permanent. So why doesn't the government have at least a rational or significant interest in enforcing its TPS scheme that it has been enacted?
I think this goes to another way in which our claim is different from all of the claims that are addressed in prior cases, which is the relief we're seeking here is also only temporary. We're only asking that people be allowed to live with their parents and in their country until they reach the age of adulthood.
So would that mean that even if the Secretary had properly made a procedurally proper determination of terminating TPS status, let's say for Sudan, that your claim is that the child would still have a constitutional due process interest not to have his or her parent go back to Sudan, even under a properly applied, within a statute, a TPS determination?
Yes, Your Honor. And if we get past the motion to dismiss, we would expect the court to address this issue on the merits only if the court first found that the TPS holders had no claim. So it's only if we lose the APA claim, lose the equal protection, lose due process for the TPS holders that the court would then address this issue. And yes, it is a right, even if Sudan now no longer meets the conditions for designation, you still have a problem. You have, H-Nida Senemat wants to play flag football next year. They don't play flag football in Haiti. She's a teenager. She's grown up here her whole life. Even if the Secretary dots all the I's and crosses all the T's in terminating TPS, you still have now children having to make this very, very difficult forced choice. And so the question the Due Process Clause asks is, does the government have a significant interest in forcing them to make that choice now, rather than allowing them to wait until they become adults, when, obviously children leave their, parents and go off into the world once they become adults. And
that would apply regardless of the legal status. Putting aside TPS, wouldn't your argument apply regardless of the legal immigration status of the parent?
No, Your Honor. Again, it turns on the government's interests in each particular context. So, for example, a person who has been here unlawfully, and the government then has a stronger interest in enforcing the immigration law than it does for people who have lived here lawfully.
That would overcome the due process rights of the citizen child who was born here, for instance, and would be forced with the same sort of Hobson's choice that you posit of having to go back with their undocumented parent to their home, to the parent's native country, or live without that parent. That same Hobson's choice would obtain. But you're saying in that instance there's a significant government interest if the person is not here legally.
Well, it's a different question, Your Honor. That is, I'm not saying that person always loses, or maybe they lose, maybe they win, but it's a different question because the government's interest is manifestly stronger. And this just goes to one other point I want to make on this, Your Honor. There's no question that this claim that we're raising, there's no case before that has addressed the same claim. It's novel. But that's not surprising, because what we have here is a situation where the government is, as far as we can tell, this has not happened in our country's history. You've got a set of 400,000 people, all TPS holders, but more than 200,000 from these countries who have lived here lawfully for at least 8 years, and in many cases for decades. So they've lived here lawfully for 20 years, and now there's not any allegation that they individually did anything wrong.
That's not the criteria. That's not what TPS is set up for. It's not about wrong or right behavior. It's about conditions, temporary conditions in the native country.
Yeah, absolutely, Your Honor. This is an argument that even if the statute were properly followed, where you've allowed people to live here lawfully for 20 years, that you cannot then, I mean, often people have children when they have lived in a place for 20 years, right? So then it gives rise to different kinds of rights than what we have seen in other cases. And if the government had repeatedly, for example, say, canceled the green cards of people who were married on the ground that we don't want to favor those anymore, or said children who are adopted no longer can adjust their status, and so we're getting rid of that, then we would have seen cases like this and this issue would have been addressed. Those are actually, I think, closer analogies to what we have here. People lawfully living here for a long period of time. Yes, under a temporary program, it's true, but they're lawfully living here, and then, through no fault of their own, the government seeks to take away their status, which puts their children then into this impossible choice. And that's the reason why I think it's different from a situation Your Honor describes where, well, if a person's unlawfully lived here for a long time, well, the government hasn't blessed their presence, and so its interest in enforcing the immigration law is greater in that instance. You know, a person who...
Well, why is it greater than allowing somebody to come conditionally, subject to certain conditions, and then determining those conditions no longer apply? Why doesn't the government have that same interest, saying, in enforcing that law as it would enforcing a law that restricts entry in the first place?
Again, Your Honor, I think it really turns a lot on the fact that this is temporary. The relief that we're talking about that would be granted here in order to vindicate this constitutional right is also still temporary. So it doesn't change the temporary nature of the program. It just provides that people who have children, those school-age children, they'll still be forced into a brutal choice, but they'll be forced into it once they're adults rather than while they're still children. And I think that certainly renders it different from all of the cases that both sides have cited before, where what people are seeking is the right to live here permanently. So if you look at the suspension of deportation cases, or in Gebhardt it's adjustment of status, in Morales it's to adjust through marriage. All of these people are trying to win the right to permanently reside in the United States. And usually, Gebhardt is an unusual exception. Usually the plaintiff is the non-citizen. You know, and here, I think if you look at it from the child's perspective, because our plaintiff, the lead plaintiff in this case, is Krista Ramos. You know, she's a teenager. She's here in the courtroom today, actually, as are some of the other children and also their parents in this case. You know, she is a teenager who has grown up in this country. From her perspective, there's no government interest in her being forced to be sent to a country that is, it's the highest murder rate in the world outside of a war zone, El Salvador is.
But the action being challenged, that's a consequence of enforcement. I mean, the action is not directly on her. She's not being ordered to be deported. So the question is, does the government have an interest in removing those who no longer enjoy TPS status or any other legal status? And I guess the way you would phrase it is removing them now as opposed to waiting until their child reaches majority age.
That's correct, Your Honor.
And you know, I would assume, I'll give counsel a chance to respond, but I assume the response is, you know, there is an immigration law that sets forth certain requirements and priorities in terms of who can be admitted, under what circumstances, and for long, and the government has at least a general categorical interest in being able to enforce those laws, so long as the laws themselves don't contravene the Constitution. For instance, if they're, you know, if there's another constitutional problem, equal protection problem, it's different. But if it's a lawfully enacted statute, doesn't the government have, and this is not a compelling interest test, this is, as you say, a rational basis with a bite, not sure exactly what that means, but a very significantly lower standard of review constitutionally.
Your Honor, I think, if I may, when you say, well, it has to be duly enacted, there may be other constitutional constraints, I think that is the central issue for us as to whether or not we're going to survive the motion to dismiss on this claim. If the government, for example, could discriminate on the basis of race and say, we want to get rid of all the people who, you know, are, I won't use the ugly words, but, you know, made some racist statement, and then if Congress wrote a law that enacted that, the Equal Protection Clause would constrain the government's power to deport people on that basis. The First Amendment does. There's actually cases that hold that, Bridges v. Wixon and Bridges v. California.
Right, so that's where there are particular problems, constitutional problems with the statute or the ordinance or the executive or whatever it is that's being challenged. I'm asking as a standalone, this due process argument, which assumes there's no other problems in order to be able to assert this claim. Now, if it's dependent on an APA problem, on an equal protection problem, okay, then I can understand that. But if it's a standalone and you're saying even if there's no other constitutional problem with the statute, even if it complies with the APA, even if it's administered consistent with the statute, that any termination of TPS status would have to give way to the minor's rights to have their parent with them.
Yeah, and just the point of the point I was trying to make, perhaps not articulately enough earlier, was you could have a duly enacted statute that had an equal protection problem, or you could have one that was a problem just as applied, like in the First Amendment context, to this particular labor organizer or whatever it is, right? Here, the substantive due process component of the Due Process Clause is another substantive constraint on the government's power to write immigration laws, even if they are otherwise duly enacted. They don't come up a lot because the government doesn't do this kind of thing very much. But if the government now wants to force a set of children into this horrific choice, there is a substantive due process body of doctrine. There's plenty of cases that say the family integrity right is fundamental, the right to stay in the country is absolute. There are cases, we cited them, where
Again, why wouldn't that
choices.
apply to every deportation of a parent?
Right. So it doesn't apply to every deportation because it only seeks temporary protection. It doesn't. We're talking about sending people to countries that have been found to be dangerous, and it's limited to people who were lawfully present for a long period of time. If you're here for less than 5 years, this doesn't even kick in.
But if somebody were here lawfully but lost that right because of conduct, for instance, lost their permanent residency right or lost whatever, temporary status right, they're here for a period. And if they're here on a student visa or work visa, and then that ends, but they had a child during here, they're here lawfully. But at that point, that lawful period ends, the visa may be limited to 5 years or something. Are you saying if they've had a child, they can't be removed? If they then lose that protection, they've been here lawfully.
Right. So the lawful, there's two different hypotheticals there. The lawful permanent resident, the statute, the way it's written, you don't lose your status unless you've done something wrong. Almost unless you abandon your status as a tiny little, but for the most part, lawful permanent residents only get deported because they are convicted of crimes. And that is really telling because if Congress suddenly said, no, we're going to strip lawful permanent resident status for all of these people, I think they would have, not because of any wrongdoing, because we're worried about the effect of it on the labor market. And we don't care that they have children in high school who are here. Then the children might have a constitutional challenge to that. And I think that's actually quite analogous to what we have here.
Well, that's lawful permanent. So what if somebody's here lawfully on a temporary status, like some kind of visa?
I think the student visa, and this is why we have very deliberately limited this claim to school-aged children. That's both a top barrier, that is, once you become an adult, the right no longer, the interest, we're not asserting that interest justifies this, and also the young age. And if you're younger than 5, we're also asserting that you're not part of our class. And the reason for that, there's 2 reasons for that. One reason is because I think it is much harder for a school-age child to move. Most people wouldn't even move their school-age children from, in high school from LA to San Francisco or something, let alone to Haiti or Sudan. So there's this additional trauma on the child. But the other reason for it, Your Honor, is because the government then has an interest in avoiding, I don't even like to use these words, but like the anchor baby problem, and that's what these cases are talking about, is like people, sort of the government's interest, you'll undermine the immigration law if people have children. But here, the government can run a temporary program, and it can run student visas, and it can have all worker visas, all these things for periods before the citizen children become a school age. And once they become a school age, it's a more complicated question. So your hypothetical, the narrow one where I think there might be a similar claim, I don't know, there's a lot of other interests involved, but a person who came here on a student visa and stayed here more than 5 or 8 years, 8 is the shortest time we have in this case, then perhaps they would have a similar argument, and that's really like the only hypothetical which I think actually could be potentially similar to the one that we have here. That hasn't really arisen in the case as much.
That suggests that every time, when the government issues some kind of temporary status for somebody, that the interest in enforcing the deadlines and the temporary nature of that is not significant, not rational, not whatever the standard is, enough to override, if they have a child, the child's due process rights to stay here and have their parents stay with them.
Well, I'd say two things about that. First, the government has 5 years. They can extend TPS once, twice. If these are 18-month extensions, even 3 times. When it goes beyond that, when you're telling people you can live here for more than 5 years, that implicates different interests for their children. Their children then are growing up. That's a 5-year-old who's grown up in
It
this
almost
country.
becomes like an estoppel effect on the government. If the government goes beyond 5 years, the government risks not being able to control and terminate TPS status, at least for those who have children?
Until they reach the age of majority, Your Honor. And the alternative, Your Honor, the alternative view, the government's view, and what you'd have to accept, I think, to accept the opposite is that there is no family integrity right here. Right? That the immigration law always categorically trumps the family integrity right no matter what. Bustamante...
Well, in between, you say there's a family integrity right that's acknowledged that may be sufficient to implicate due process, but the interest in exercising a validly enacted law that's not tainted in some other constitutional way survives rational basis review.
Right, and I guess I don't know why substantive due process in that sense would be subordinated in a way and rendered it weaker somehow than equal protection, the First Amendment, I don't think there's any doctrinal basis for that kind of lower treatment. And I also...
Well, yes, there is, because you are asserting under the Equal Protection Clause not just rational basis, but strict scrutiny, because this is based on racial or ethnic animus.
Right.
That's a different level of review, and if that is a cognizable claim, if that claim can be heard with, this court has jurisdiction over it, and you're able to prove that, that's a whole different animal. If you were just using regular rational basis review, courts have rejected all sorts of classifications in the immigration context in that sense.
Yes. My point only, Your Honor, is that under the government's view, there is actually no substantive due process right that's enforceable here at all because it's immigration law. And so some of these hypotheticals, I'd be curious to hear what they think about those. Could the government just get rid of all the, say, adoptions on the basis of people who've gotten green cards through adoptions? They just pass a law tomorrow that says, okay, those are gone. Or all the marriages that are based on green cards, those are gone. Say the government has an interest here, it's duly enacted, you can have in your deportation hearing, you can challenge whether or not you got your green card through adoption or your green card through marriage. So you have all the process in the world, but there's no substantive problem there. And our view is there is a substantive right that's implicated in these cases. And Bustamante and Cardenas and Din v. Carey, the cases that are about people who are marrying people abroad, right? They're U.S. citizens, they're seeking to marry non-citizens who are abroad. Bustamante is very clear that this implicates the substantive, that's the word they use, the substantive right to no government interference in matters of marriage and family or something like that, and citing the cases that we have been talking about. So the Ninth Circuit has recognized that there is obviously some substantive right here that has to be balanced. And so then the question is whether these very particular factors, where the people have lived here lawfully, where the children are going to be sent to countries that are unsafe, where it's a temporary protection, whether those are enough to alter the balancing calculus here compared to these many other situations where the interests are different.
Let me hear from the government. The government does argue in its brief that there's not even a cognizable interest that, if it were to be recognized, is overridden fairly easily. I think the government is arguing there's no due process right at all to be recognized. Is that the position?
Yes, that is the first point, Your Honor, that there is no right. But even if we were in a world where there were some process of the type in Bustamante or Cardenas, it's important that the standard there was the government only had to give a facially legitimate, bona fide reason, and that was the end of the matter. So this, the idea that those cases would somehow support the types of scrutiny of the Secretaries of Homeland Security's decisions here, I think is would be unwarranted.
Well, maybe it's an academic, I mean, view that position, it may be academic, whether you recognize any due process right to start with. Do you have any response to the hypothetical about green cards being revoked when they're based on marriage or adoption, whether any constitutional right would vest in that situation?
The government's position is that no constitutional right would vest in that position, Your Honor.
But even if it did, you'd have, well, if it did, then you'd have to look at whether there's, I guess as you put it, a facially legitimate, valid reason.
Bona fide reason.
Bona fide reason. What about the argument that this is not asking for full permanent status, but really temporary status, really, status that would be extended, tied to the age of the child, and therefore it's not as sort of broad or intrusive as affording, for instance, permanent residence to somebody by marriage or something like that?
Well, I think two things, Your Honor. First, that's inviting this court to create basically a new immigration status out of whole cloth, and which goes to the second point, which is that these types of fixes are appropriate for Congress. That the concerns that were noted by plaintiffs' counsel are legitimate concerns. But we have a branch of government that is entrusted with remedying that situation, and that this is a legislative fix. It's not appropriate for the judicial construction of a new type of immigration statute.
All right, let's move on to the equal protection question, and which I'd like to hear from plaintiffs' counsel, make sure I understand the scope of that claim. Are you challenging the actual termination, the determination to terminate the status, TPS status of these four countries, both as sort of directly as well as challenging the change in rule as violatively, or just the change in rule being motivated by improper purposes?
We're challenging both, Your Honor. The change in rule is one of the elements under Arlington Heights. You look to procedural departures, and so the change in rule supports the claim of intentional discrimination, but we are not only challenging the change in rule.
But also the substantive determination to terminate.
And not because the conditions in the country are not such as the Secretary found them, but because the decision was motivated by intentional race-based discrimination.
Well, the Supreme Court may shed some light within
We were checking our email this morning, Your Honor.
I take it no decisions come down. So in some ways it's hard to adjudicate this, since a large part of perhaps not all of your claim, your theory of equal protection is based on comments made by the President. And I don't know how much useful it'll be to explore the issue, since I think the Supreme Court may be looking at that, but it does raise the question of, if you, number one, can you consider those comments made? Are we limited to time frame? Does that extend to comments that were made not proximate in time but distance away? Can you consider President's comments made while he was a candidate and not a president? And what's the end? What is there a point where any action taken in this arena by the President can be deemed not tainted? Is there some purge period? I assume the Court is going to may make some comment on that, but in case it doesn't, I would like to hear your response to the limits problem.
Under current law, obviously, Your Honor, that's the only way we can answer the question, but the Court can consider that range of statements. The government has an argument here that the statements are not relevant because the ultimate decision maker was the secretary. That argument clearly fails under the cat's paw theory of discrimination, which is what the court in the Eastern District of New York found in the Bataya Vidal case.
Yes, I'm not so concerned with who's making the statement. I'm more concerned with how far back can you go, how much of a causal relationship needs to be demonstrated as a foundation to consider these, and what's the limit?
I understand, Your Honor. As to the limit, under the Arlington Heights test, it's a very sensitive inquiry, I think is the word the court uses. You look at the totality of the circumstances. There is no one factor that is controlling. We would assume in good faith, Your Honor, that if this court were to find that the TPS terminations at issue here were infected by discriminatory animus, that the government would go back and make a good faith effort to redetermine the TPS designations in a constitutional manner. And there is nothing under existing law that would prevent them from doing that even after a finding by this court about intentional discrimination. You could look to, for example, the zoning context. There have been, of course, many cases finding that a city made a discriminatory decision to deny a zoning application, and I'm not aware of anyone ever suggesting that the city could no longer deny any zoning applications in the future because that one instance was infected by discrimination. Each decision has to be looked at on its own terms.
So if the subsequent decision is examined under the criteria of Arlington Heights, notwithstanding an earlier statement made by a decision maker, it could withstand equal protection scrutiny?
That's correct, Your Honor.
So would the proximity, what role does proximity in time have to this analysis?
I think proximity is relevant. Under Arlington Heights, the Ninth Circuit has been clear that this is really a question for a trier of fact, and any indication of discriminatory intent can lead to an issue that can only be resolved by the trier of fact, so proximity goes to that. Our allegations have a tight proximal connection in that there was a meeting about TPS predated by a week, some of these TPS terminations, at which the president made statements directly about the TPS holders.
And as I recall, it was in reference in more particularly to Haiti, TPS holders from Haiti and El Salvador?
Those were the terminations that immediately followed the meeting, Your Honor, but the president's statement, and I don't want to say it to the court, but I do think his words are important. He said, why are we having all these people from shithole countries come here? And a reasonable trier of fact could infer he was speaking about TPS holders in general. That statement was not tied directly to Haiti. He made other comments
but the
about
predicate,
Haiti.
I'm trying to remember now, before he made that comment,
Yes.
was the discussion specifically about Haiti and El Salvador?
The discussion was, as we've alleged, Your Honor, as I understood it, about TPS in general. The countries that were coming up immediately were Haiti and El Salvador.
So you would contend that his reference was to all TPS holders?
Yes, Your Honor, and we think that's also supported by the allegations about the pressure that the White House put on the Department of Homeland Security, even in advance of that meeting. In November, we've alleged that the Chief of Staff at the White House called the acting Secretary Duke, put tremendous pressure on her to end Honduras, TPS for Honduras, in the context of saying the TPS program in general is contrary to the Trump administration's goals on immigration.
Well, I'm not sure that supports your claim of racial or ethnic or color animus, because if it's to end TPS generally as an immigration matter, which raises the question, if there's a general attitude about immigration, you might even call that anti-immigrant sort of sentiment, that's not necessarily racial animus. That could be, so I'm not sure, I was puzzled by that reference. I'm not sure how that supports your claim. A general pressure to end and tighten up the TPS program is not necessarily one that's expressly race-based.
Let me clarify, Your Honor, and I think you take that pressure is relevant to, one, the president's involvement in the entire process and whether you could hold the secretary responsible for the president's animus infecting the process. But it is also relevant because we've alleged that the president's position on the TPS program is due to his animus towards immigrants from non-white, non-European countries. So the TPS holders are from specific countries, which the president contrasted to countries like Norway, which are mostly white. And so it's not, our allegation is not that the administration was opposed to TPS because they were opposed to the program, but that TPS was contrary to their overall goals, which were motivated by intentional discrimination toward non-white, non-European immigrants.
All right. Yeah, go ahead.
If I could address for a minute, Your Honor, the standard of review.
Yes.
The government's primary argument here is that rational basis review applies, and because the Federal Register itself doesn't make any race-based claims, they should pass rational basis review. Obviously, Arlington Heights, it's our position that Arlington Heights applies. The government cannot satisfy any standard of review here. They've pointed to no case, and we're aware of no case, that has applied rational basis review to a claim of intentional race-based discrimination. But even under rational basis review, a law that's motivated by animus would fail to pass constitutional muster. That's clear from Claiborne and Moreno. And as I understand it, the government's response to that is, well, to allege animus in the immigration context, you need to show outrageous discrimination. And they cite the AADC case. That is a case, Your Honor, that is about selective enforcement claims. It's fundamentally different than this claim. AADC was a situation where you had people who were in violation of the law, who were challenging their prosecution for violation of the law on the basis of the prosecutor's motive. The result of that, the court was concerned that the result of success on that kind of challenge would be to delay prosecution of a violation of law, or in the immigration context, to permit an ongoing violation of law. Our plaintiffs are not in violation of law. This is not an issue where the government is choosing from among a set of people who are in violation of law who to prosecute, and we're challenging their motive in doing that. And I think the Ninth Circuit in the Kwai Fun Wong case was quite clear that AADC is limited to that kind of selective enforcement context, and that it does not apply when you are challenging denial of an immigration benefit on the basis of discriminatory animus.
Right. Well, let me hear from the government on that. Your assertion that the proper standard of review here is the AADC standard. Why is this, where is there an assertion of prosecutorial or an impingement upon prosecutorial discretion? It's not prosecution here. This is really has to do with the implementation of a statute.
Well, Your Honor, it's important to note that the AADC framework has been applied, particularly in the NSEERS cases, to immigration laws that were distinguished on the basis of countries. You know, the NSEERS was the selective registration system, and at least the First and the Seventh Circuits applied AADC and that rational basis framework to the requirement that individuals from certain countries have to register.
Well, but wasn't that in the context, remind me, was that in the context of either prosecution or removal proceeding?
Yes, Your Honor. Yeah.
So that makes some difference, does it not? I mean, one could analogize removal. Once you get into removal proceedings, it's perhaps similar to a prosecution, and to say that people are selectively being, chosen for removal in a way that is based on some allegedly impermissible criteria, and therefore seeking court intervention to try to stop that. It's similar. Maybe it's not a criminal law enforcement, but it is a law enforcement action that's analogous to kind of a prosecution for purposes of the selective prosecution doctrine. So I could kind of see that, but here we're not at that stage, it seems to me.
Well, the predicates that would put us in that stage are like the NSEERS cases. I mean, you had specific requirements from individuals for specific countries that were distinguishing based upon national origin and NSEERS. And here you have country-specific determinations that are not about the characteristics of individuals from these countries, but are about the conditions in those countries on the ground. And in both cases, the framework is going to be an AADC framework because of the immigration context.
Well, but that suggests that any kind of decision, even if it's one based on invidious factors, if it is a predicate to later removal or later some kind of individualized process where there's some sanction, would be kind of forced under the framework of AADC would be a pretty sweeping proposition. That would mean normal constitutional review would be constrained, even if you're not actually in a prosecution.
Well, it might be sweeping, Your Honor, but in the context of immigration, where you're challenging the executive's ability to weigh a myriad of factors, of foreign policy factors, humanitarian considerations, domestic political considerations, that the deference to that that decision-making process is what AADC and in serious cases, even outside of the prosecutorial discretion context, are counseling.
Well, that's two different doctrines. One is concern about the separation of powers in the court not intervening too forcefully in the prosecutorial discretion area, which is one thing. The mantle of immigration law and the deference to Congress's plenary power, that's a different matter. I mean, that's another basis for deference and a court treading very lightly, but it's not based on the prosecutorial discretion. So and I think AADC is really about prosecutorial discretion, selective prosecution.
Just one thing on that, Your Honor. The reason for the deference applies with equal force here, because whether it's prosecutorial discretion or the weighing of the country conditions, both are inherently executive functions. So for that reason, AADC would not be limited to just the prosecutorial discretion context, but it would apply also to a context here where you have an inherently discretionary assessment in consultation with other government agencies about what the realities on the ground in a country like Sudan or Nicaragua or El Salvador or Haiti are. That the rationale for deferring to prosecutorial discretion applies with equal force to the rationale. It would apply with equal force to deferring to the discretion in assessing the factors that are relevant to TPS here.
Well, that may be a reason why the statute and Congress enacted a statute to generally bar review of substantive decisions, and I think that's acceded to by the plaintiff. If there was a decision based on analysis of the facts on the merits, courts are not going to second guess, sort of the Secretary's assessment of on-the-ground conditions. But if the decision proves to be motivated by racial animus and not, by an actual assessment of things on the ground, I'm not sure there's a reason for deference there, because then the whole reason to defer to the expertise of the agency and the weighing of various considerations, if that's not what's really at play, then there's no basis for that kind of deference. So, I mean, I think the two sort of dovetail, that unless you get out of that box and if you can prove this was motivated by a reason that's not based on the merits, there would be very, very limited judicial review. But if you can prove that, then it seems to me that normal scrutiny, strict scrutiny would apply to any governmental decision, as would apply to any governmental decision. What's your view about, I guess, again, we'll may find out more within days how we are supposed to assess comments and evidence, but the fact here that there's proximity between the alleged the comments that are cited by the plaintiff, the President's comments about shithole countries and comparing TPS countries to like Norway as an example, that it was within a short time, I think 1 week before I think the first decision was made with respect to Haiti, or was it Haiti?
I think I might be confused on the time frame. I think those comments were made after Sudan and Nicaragua.
After.
After.
And then, but before Well, it was within a week. Is that, I recall that there was a,
I'm fuzzy
Comment.
on the exact time frame.
but within a short time. So, I mean, whatever the record, I mean, wouldn't that normally be deemed fairly probative if this were just any other case, comments made by the decision maker that shed some light on that decision maker's attitude in connection with the transaction close in time? It seems like that would be given weight in a normal case.
Well, if this were a normal sort of employment discrimination case, yes, Your Honor, but this is not an employment discrimination context or that other set of contexts.
But the same logic would apply. I mean, the reason why it's given weight in an employment context or in a zoning context or any other decision-making context is that just logically, if, the closer in time it is, the more likely it may shed light and on what the decision-maker was thinking at the time.
Well, Your Honor, again, this is, plaintiffs have expressed their view on this argument, but we have a congressionally designated decision maker who is a cabinet secretary who makes these decisions. And that is a reason why this isn't a normal context. And for that reason, President's comments are, our position is that are irrelevant to the decision-making process here. And in fact, that some of plaintiff's allegations are actually self-refuting on this. They make a lot of Secretary Kelly's alleged pressure on Acting Secretary Duke regarding Honduras.
Yeah.
She did not terminate Honduras.
Well,
Similarly, with Sudan, she extended South Sudan, and Secretary Nielsen has extended Syria. So when you look at the particular allegations of discriminatory pressure here, they fall apart under that scrutiny.
well, that's a factual question, and I know you've raised that. It sort of shows that there was not perfect control. Even assuming that the President's agenda was to end TPS status for any non-white country, that didn't happen in at least 3 instances. But the fact that it happened in 4 other instances may be evidence to the contrary. But that's an evidentiary question. I think their theory is that even though the charged decision maker by statute was the Secretary, if the Secretary was in fact acting under the pressure or influence of the President, then as under typical discrimination theory, those who exerted some influence or pressure, their state of mind can be imputed for liability purposes to the ultimate decision maker.
Well, as you're aware, there's other pending litigation on this. The Casa de Maryland case rejected this argument. Batala v. Dow has been certified for interlocutory appeal, and there are other courts considering this issue, but in all of these cases, it is our position that when you're dealing with a cabinet secretary who has the authority to make these decisions as delegated by Congress, that this sort of undue pressure cat's paw theory falls apart.
Simply because that's the person that was designated to exercise the ultimate power?
Yes, that distinguishes it from a case of a middle manager in the employment context or these other sort of contexts.
I'm not sure. I mean, ultimately, somebody's a decision maker. In this case, it's designated by statute. In many cases, you have to figure out who the decision maker was. Was it the supervisor, the manager, the CEO? But once you've determined who that decision maker is, you also look at those who influenced the decision maker in determining whether or not there was unlawful discrimination or other invidious type of conduct that was going on. And so I'm not sure the fact that Congress has identified who the ultimate responsible decision maker is would insulate and prevent review of who the other influencing factors were and whether or not they were tainted by some unlawful motivation. I'm not aware of, why that would be.
Well, fair enough, Your Honor. This is our position, and we'll also have a Ninth Circuit decision in DACA that will shed some light on this, perhaps.
Right.